All right, welcome everyone. If you're an international legal professional, you know the world of corporate law is changing fast. And today we are going to dive deep into the language of one of the biggest drivers of that change, data privacy. Let's jump right in.
So here's our game plan. We're going to treat this just like a technical legal briefing. We'll start by nailing down a really critical distinction. Then we'll build up our vocabulary with some essential terms. After that, we'll map out who the key players are, talk about why this is so critical for your clients, and then, finally, we'll put all this language to work in a practical way.
Okay, first things first. In legal English, as you know, precision is everything. Ambiguity is your enemy. And that is especially true when we talk about privacy and protection. People use these words interchangeably all the time in normal conversation, but in our world, they have very distinct legal meanings.
So here is the core distinction you absolutely have to master. Think of data privacy as being all about the rights of the person. It's about their control over their own information. You can think of it as the what and the why. Data protection, on the other hand, is about the safeguards. It's the how. We're talking about the technical stuff, the encryption, the security protocols, all the measures that actually enforce those rights. Getting this distinction right from the get-go is the foundation for giving solid legal advice.
Okay, now that we've cleared that up, let's build our technical vocabulary. Honestly, knowing these terms inside and out is non-negotiable if you want to operate effectively in the international space. These are the words that show up in contracts, in policies, and yes, in litigation.
First up, the data subject. This is the central character in this whole story. It's the person whose data we're talking about. Could be a customer, an employee, a patient, you name it. From a legal standpoint, they are the one who holds the rights that you, as a lawyer, are trying to navigate on behalf of your client.
Next, the data controller. Now this is the main decision maker. This is the organization that's deciding why and how data is being processed. 9 times out of 10, this is going to be your client, the corporation, the hospital, the university, and this is critical. This role carries the lion's share of the legal responsibility and liability.
And right alongside the controller, you've got the data processor. This is any third party that's handling data for the controller. Think about cloud services like AWS or a company that processes payroll. For you as counsel, the contract that defines this relationship, the DPA or Data Processing Agreement, is a hugely important document where you'll be negotiating risk.
So what exactly is processing? Well, you need to know that the legal definition is huge. I mean, it is deliberately incredibly broad. It covers pretty much anything you can do with data, from the moment you collect it, to storing it, using it, and all the way to deleting it. This massive scope is one of the main reasons compliance can get so complicated.
Okay, our last term for this section is a bit technical, but super important: pseudonymization. It's really crucial not to confuse this with total anonymization. With pseudonymization, you're replacing the direct identifiers, but, and this is the key part, the data can still be traced back to a person if you have a separate piece of information, like a key, that's stored securely somewhere else. Understanding this is vital when you're advising clients on how to minimize risk.
All right, so we've got the vocabulary down. Now let's put these words into context and map out the real-world players. You have to understand who these stakeholders are and how they relate to each other to really navigate this complex world of data governance.
This table really lays it all out. See your client, the controller? They're sitting right in the middle of this web. They're giving instructions to the processors, they're being watched by the regulators, and they have very real duties to the data subjects. Your job as international counsel is to manage all of these complex and often competing interests. Okay, we've got the terms and the players. Now we get to what might be the most important skill of all. How do you take all this technical knowledge and translate it into advice that your clients will actually listen to? Let's get into the why.
So how do you start that conversation in the boardroom? Well, it all begins with changing their perspective. You have to get them to stop seeing data privacy as just another line item, another cost of doing business, and start seeing it as a core part of their entire business strategy.
These are your talking points. First and foremost, you talk about trust. It's the bedrock of their relationship with their customers. Second, you talk about compliance and the massive fines under laws like GDPR that they want to avoid. Third, you talk about security and preventing fraud. And finally, you bring up the bigger picture: ethics and protecting fundamental human rights. You've got to speak the language they understand: risk, reputation, and responsibility.
All right, let's bring it all home. In our final section, we're moving from just knowing this stuff to actually using it. How can you wield precise legal English to communicate these ideas effectively and protect your client?
Okay, time for a quick, practical grammar challenge. This is a scenario you'll definitely come across when talking about legal compliance. Have a look at the sentence on screen. How would you fill in that blank to talk about a past habit that's no longer happening?
And the answer is used to share. Why is this little phrase so powerful? Because used to perfectly and precisely describes a practice that happened in the past, but, and this is the key, has been stopped because of new rules. It's a small detail, but that kind of precision is what legal English is all about.
So let's apply this in a real-world situation, like structuring a persuasive voicemail or an email to a busy executive. This 4-step framework is your best friend. First, get straight to the point. State your purpose. Second, quickly define the issue and why it matters right now. Third, connect your advice to those big imperatives we talked about: trust, compliance, risk. And finally, offer your help and open the door for more discussion. It's a simple way to turn complex analysis into advice that is clear, actionable, and gets results.
And we'll end with the question for you to take away. As you're working in this space, really think about this. Who do you think faces the biggest challenge here? Is it the controller, who has all the responsibility? Is it the processor, who has to manage the nitty-gritty tech? The regulators with their limited resources? Or is it the individual data subject who's just trying to understand what's happening to their information? There's no single right answer, but how you think about it says a lot about the future of digital law.